Hello, everyone. Thank you so much for joining me on this presentation. Today, I'm going to be talking about the Violence Against Women Act, or VAWA. I'm going to look at it not just as a criminal justice law, but as a public health policy shaped by feminist legal theory, constitutional limits, and evolving ideas about who deserves protection. I'll walk through how it was created, how it's regulated, how it's changed throughout reauthorization, and what ethical tensions it still carries today. So VAWA was enacted in 1994 as part of the Violent Crime Control and Law Enforcement Act. It really hasn't been around for a very long time. Before this, domestic violence and sexual assault were often treated as a private family matter. Feminist activists pushed back against that framing and argued that violence inside the home is still violence and that the state has a responsibility to intervene and protect women. VAWA created a federal role in funding and coordinating responses to domestic violence, sexual assault, and stalking. Instead of directly controlling states, the federal government distributes money through the Department of Justice Office on Violence Against Women. So states, tribes, and local agencies receive the funding, but they have to meet specific requirements in order to receive the funding. So since the beginning of this law's creation, it has functioned through a grant-based system. I want to touch on the feminist theory foundations that I feel really shaped the origin of this policy. The phrase, "the personal is political," I feel really captures the shift that happened in the 1970s and 80s. During this time, it challenged the idea that domestic violence was a private relationship issue and instead reframed it as a reflection of gender-based power structures. VAWA is basically the federal government accepting the argument that violence against women isn't random, it's structural and facilitated by institutional patriarchal powers, and that the state does have a duty to respond. That's my spiel on that. So, okay, let's talk about how VAWA actually operates. So, going from the top down, Congress is the one who authorizes and funds the law. The Department of Justice, through the Office of Violence Against Women, administers grant programs. HUD, the Housing Authority Department, handles housing protections for survivors. The federal government uses conditional grants to influence state and local behavior. If states want funding, they must complete the coordinated response systems, train law enforcement, track the data, as well as meet compliance standards. So the federal government's role is to shape the system through funding rules. And if you don't follow the rules, you don't get funding. At the implementation level, state governments, tribal governments, law enforcement, courts, housing authorities, and community-based service providers carry out the work of supporting victims and holding offenders accountable for their crimes. So a lot of the actual justice takes place at the state and local level as opposed to federally. In United States versus Morrison, there's a woman who alleged that she was sexually assaulted and she tried to sue her attackers in federal court under VAWA's civil remedy provision. So this was a monumental case because it did change the way that VAWA operated. So what happened was the Supreme Court struck that provision down. The court ruled that Congress did not have the authority under the Commerce Clause because gender-based violence is not an economic activity. It also said that the 14th Amendment applied to the state action and not to private individuals, so victims could no longer bring federal civil lawsuits under VAWA. This didn't eliminate the law, but it did reshape it. After Morrison, VAWA relied more heavily on criminal enforcement and the grant-based systems rather than federal civil rights remedies. So the case showed how constitutional limits shape the structure of public health policy, even when there's clear harm being done. Frustrating. So here's a little timeline that kind of visually shows the reauthorization evolution. So it's gone through several reauthorizations, and each reauthorization, I think, reflects the changing norms and political power of that time. So in 2000, just 6 years after the inaction of the law, protections were expanded for immigrant survivors. In 2005, the law addressed cyberstalking and increased tribal focus. In 2013, it explicitly included LGBTQ plus survivors, as well as continued to expand that tribal criminal jurisdiction. In 2022, tribal jurisdiction was further expanded, as well as firearm restrictions were strengthened. And my prediction for 2026 is digital modernization, ? We'll talk about that in the emergent issues. But you can see how the definition of who deserves protection has expanded over time, and reauthorization becomes a way of renegotiating social values. Here's my little spiel on intersectional feminism and how it plays a role in VAWA. The great intersectional feminist theorist Kimberly Crenshaw argued that gender doesn't operate alone. Race, immigration status, sexuality, and class intersect to shape vulnerability. Early anti-violence movements often centered white heterosexual women, but over time, the law began recognizing that vulnerability looks different depending on social position. And this is where reauthorization reflects a gradual widening of who is recognized under federal protection. So, social construction of target populations. Using Schneider and Ingram's framework, we can see how VAWA distributes benefits and burdens. Institutions like law enforcement and courts in the upper right quadrant have high political power and strong legitimacy, and they fall into the advantaged category and receive substantial funding from VAWA. Survivors are, in the bottom right, are socially constructed as sympathetic but are politically weak, and they are definitely dependent on courts, law enforcement, and federal and state agencies. Perpetrators and repeat offenders down in the bottom left are low power and negative construction. And immigrant communities have historically occupied a more contested space, which influenced the timing of protections. Overall, this framework shows that policy design, no matter how much you try to make it neutral, it is not neutral, and it reflects power. Adding on to a little bit more of the feminism and ethical tensions. One tension is protection versus autonomy. How do we protect survivors without removing their agency? Another is criminalization versus prevention. VAWA relies heavily on the criminal justice system. In my research, I've found that some feminist scholars call this carceral feminism, which is the idea that gender justice becomes tied to incarceration. I had to be careful because I went down a little bit of a rabbit hole here. I think that carceral feminism would be a really good topic to explore in relation to VAWA, but that might be another topic for another day. There's also tension between surveillance and confidentiality. Data collection helps measure outcomes, but also can risk privacy. This is a very ongoing problem that we are facing, especially as we move to an even greater digital space. And lastly, institutional trust gaps matter. I would argue that most marginalized communities distrust law enforcement, which of course complicates the reliance on those systems. And lastly, protection is not neutral, and it always involves trade-offs. I'd like to briefly address the epidemiology and structural determinants. From a public health perspective, violence is a structural determinant of health. We know that over 40% of the women in the US report a lifetime intimate partner violence. Violence is associated with chronic illness such as PTSD, reproductive health issues, as well as intergenerational trauma. Housing instability increases vulnerability, and firearm access increases lethality. VAWA attempts to intervene at these structural points and not just at the level of individual incidents. Okay, emerging challenges. So, one of the biggest emerging challenges that we are seeing emerge in rapid time is technology facilitated abuse. Cyberstalking and AI generated non consensual intimate images create new forms of harm. If you didn't know, now you know that people are stealing photos of women, children, people, importing them into generative AI to create unconsensual pornographic images. The law now has to respond to harms that are digitally produced but are very real in impact. We've even seen this case happen at the high school student level. And I predict it's only going to become worse and more common unless there are restrictions and protections put in place, as well as consequences by the perpetrators. But that's neither here nor there. Other challenges include workforce shortages, funding instabilities, tribal implementation capacity, and of course, ongoing trust gaps within marginalized communities. So what should happen to modernize VAWA and continue on these protections? So, in my opinion, future reauthorization of VAWA should include a modernized statutory language around technology-facilitated abuse, strengthening prevention funding and not just a criminal response, and a stabilization in multi-year grant funding, as well as improving data governance while protecting privacy at the same time. In conclusion, VAWA is a feminist legal achievement, despite the drawbacks that it may have. It is also a public health infrastructure system. It operates through fiscal federalism shaped by constitutional limits and evolving social norms. It continues to expand as our understanding of vulnerability becomes more intersectional. And lastly, it remains ethically complex because protection always reflects power, and power structures change over time, as so must our systems of protection. And my references, of course. Thank you so much, and I hope you learned a little bit more about VAWA, as well as how feminism and intersectional feminism plays a role in it.